The Subcommittee on Health, Employment, Labor, and Pensions will come to order. I note that a quorum is present, and without objection, the chair is authorized to call a recess at any time. When it comes to saving for retirement, one thing is certain: Americans should be able to retire in confidence. They should be able to seek out investment advice from the investment professionals of their choosing, assess the wide variety of options in today's marketplace, and then make their own decisions on the best options for their retirement. The committee is meeting today to discuss the Department of Labor's newest plan to overregulate American retirement savings by imposing a costly, burdensome new rule. The so-called Retirement Security Rule expands the definition of investment advice fiduciary. This could have far-reaching implications for retirement savings and affect critical access to retirement products for millions of Americans. First, I want to point out that DOL has overstepped their authority on this issue. The Employee Retirement Income Security Act, or ERISA, gives the Department of Labor authority to regulate retirement plans sponsored by private employers. However, the broad-reaching new fiduciary rule regulates retirement accounts far beyond employer-sponsored benefits like IRAs. The rule is clearly outside the purview of the agency, yet they are trying to regulate it anyway. DOL's expansive rule is a blatant power grab, seeking to force more types of financial professionals under their control. But other regulatory bodies at the federal and state level already exercise oversight over the retirement products and services that DOL is trying to bring within its jurisdiction. The SEC Regulation Best Interest Rule requires broker-dealers to act in their clients' best interests. The National Association of Insurance Commissioners' Best Interest Rule also requires state regulatory annuity sales to be in the client's best interest. If the DOL has a real concern about self-dealing, these issues have been addressed elsewhere. Moreover, my main concern is that the fiduciary proposal will have a disastrous impact on the industry. Past versions of the DOL fiduciary rule created massive headaches for the retirement products and services industry. The last time the government tried to issue a similar rule, financial institutions were forced to eliminate or limit brokerage advice services as a result. A financial advisor in Virginia put it this way: the more layers of rules and regulations Congress and the White House add, the less likely it is that the average American will get the advice that they need. This rule will give too much latitude to the administrative state to go after anyone in the retirement business and will cause lawsuits to skyrocket. The cost of implementing the fiduciary proposal and the significant legal challenges that will follow are not fully reflected in DOL's regulatory analysis. But make no mistake, DOL is forcing retirees to be hit with the costs. Lastly, the DOL gave stakeholders insufficient time to respond to the proposal and has refused to extend the comment period. This is a major departure from rulemaking norms. For example, the 2010 fiduciary rule allowed for a 90-day comment period and an extension. The new fiduciary proposal gave stakeholders a mere 39 working days. The DOL should be busy supporting implementation of Secure 2.0 to encourage retirement savings, not proposing rules that will restrict access to financial advice and hurt our nation's seniors. Planning for retirement is already challenging enough, but the Biden administration's overreach will make that process much worse. My goal in this hearing is to be a voice for our nation's seniors and to protect those planning retirement from the heavy hand of the bureaucracy. With that, I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman. I want to thank the witnesses for being here as well. In 1975, I'd like to say before I was born, but I'm told before staff was born who wrote this, Gerald Ford was president. My Golden State Warriors won the NBA championship. 401k plans did not exist, and many Americans earned a traditional pension that provided guaranteed income for the rest of their lives once they retired. The retirement savings landscape has changed a lot since then. Nowadays, workers who participate in retirement savings plans, 401ks, are more likely to be in a defined contribution plan, such as a 401k. These workers are responsible for selecting and managing their investments as well as paying attention to fees and market trends. In today's do-it-yourself retirement savings world, it is up to the workers to ensure that they do not outlive what they saved. Understandably, many workers seek professional advice when making retirement investment decisions, particularly as it relates to rolling over their assets from their employer-provided plan to an individual retirement account, an IRA. Rollovers are often the biggest one-time financial decision workers and their families will make in their lives for their retirement. Many retirement advisors do right by their clients. Most, I would say. Unfortunately, there are those who do not. Those unscrupulous advisors steer their clients to a particular financial product with high fees that is profitable for the advisor, even if it is not in the best interest of the client. That is called conflicted advice, and it has a devastating effect and consequences for retirement savers and their families and everyone's trust in the financial system. According to the Obama administration, conflicted advice costs retirement savers up to $17 billion in losses every year. If a retiree spends down their retirement savings as normal, but experience a 100 basis point, 1% reduction in investment performance because of conflicted advice, the retiree savings would be completely depleted more than 5 years early. President Biden's Council on Economic Advisors estimated that conflicted advice in the sale of fixed index annuities, just one of the many products that could be affected, may cost workers as much as $5 billion in retirement savings per year. This is enormously harmful to workers and their families. We are very fortunate to have our witnesses and our witness, Mr. Joseph Pfeiffer, president of the Public Investors Advocate Bar Association, is one of our witnesses today. Welcome. PIABA's attorneys have worked with tens of thousands of victims of conflicted advice. These are often proud American workers who played by the rules and earnestly saved their retirement nest egg, often on middle-class salaries, and they ended up losing a substantial amount of their life savings because of bad advice. This is not fair, and it's heartbreaking for them and for Americans. Many of you may be wondering, how can this happen? Well, bad actors can get away with providing conflicted advice because the primary Department of Labor regulation, which dates back to 1975, is riddled with loopholes. And neither the SEC's regulation best interest nor the National Association of Insurance Commissioners model rule are sufficient to address the problem. Fortunately, the Biden administration has proposed a common sense, narrowly defined, and not narrowly tailored rule that is aligned with the current do-it-yourself retirement savings landscape. The Biden administration's retirement security rule levels the playing field and will ensure that workers, retirees, and retirement plan sponsors receive advice that is in their best interest. According to Morningstar, the Biden administration's retirement security rule would have significant benefits for retirement savers. For instance, average cost of workers covered by a small plan would drop from 93 basis points down to 75 basis points, while there would be minimal charges for most other plans. And retirement plan participants would save over $55 billion in the first 10 years of the rule and over $130 billion in the subsequent 10 years. I strongly support the Biden administration's retirement security rule. It will particularly help those with small account balances, and since those small savers are most vulnerable to conflicted advice. By taking action, the Biden administration demonstrates that it understands what's at stake for American workers and families. As our witness will put in his testimony, quote, "The difference between getting conflicted retirement advice and receiving advice in the investor's interest is sometimes the difference between the retiree being able to visit their grandkids or not, the difference between being able to afford a retirement home close to their children or living with them." Those are the people who will be harmed by the broken status quo and who will benefit the most from the Biden administration retirement security rule that we will discuss today. I thank the chair and I yield back.
Thank you, Mr. Saulnier. Pursuant to Committee Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m., 14 days after the date of this hearing, which is February 29, 2024. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official record. I will now turn to the introduction of our distinguished witnesses. Our first witness is Mr. Doug Omen, who serves as the Insurance Commissioner of the Ohio Insurance Division and is located in Des Moines, Iowa. Mr. Omen was appointed as Insurance Commissioner by the Governor of Iowa in 2017. He served on the National Association of Insurance Commissioners Working Group that drafted the NAIC Best Interest Rule. He previously served in the Missouri Attorney General's office working on consumer fraud issues. He has a law degree from St. Louis University School of Law. Welcome. Our second witness is Mr. Thomas Roberts, who is a principal with the Groom Law Group located in Washington, D.C. Mr. Roberts has practiced law at Groom Law Group since 2011. Previously, he served for over a decade as chief counsel of ING U.S. Legal. Mr. Roberts has counseled clients for over 20 years on issues related to ERISA's fiduciary responsibility and prohibited transaction rules. He has an AB from Georgetown University and a JD from the Georgetown University Law Center. Welcome, Mr. Roberts. Our third witness is Mr. Joseph Pfeiffer, who is the president of the Public Investors Advocate Bar Association and is located in Norman, Oklahoma. PIABA is a trade association for plaintiff attorneys who represent investors in disputes with the securities industry. Mr. Pfeiffer is also a founding partner of the law firm Pfeiffer, Wolf, Carr, Kane, Conway, and Wise in New Orleans, Louisiana. His practice includes representing individuals and institutions that have been harmed by investment banks and brokerage firms and prosecuting ERISA class actions. He has a BA from Bowling Green State University and a JD from Tulane University Law School. Our final witness is Jason Berkowitz, who's the Chief Legal and Regulatory Affairs Officer for the Insured Retirement Institute in Washington, D.C. IRI is the leading association for insured retirement strategies, including life insurers, asset managers, broker-dealers, banks, marketing organizations, and law firms. Mr. Berkowitz joined IRI in 2012. He started his career as a corporate attorney at 2 national law firms before working in government affairs for the Hartford Life Insurance Company. We thank all the witnesses for being here today, and we look forward to your testimony. Pursuant to committee rules, we ask that you would each limit your oral presentation to a 5-minute summary of your written statement. And I'd also like to remind the witnesses to be aware of their responsibility to provide accurate information to the subcommittee. So we will first recognize Mr. Omen for 5 minutes.
Chairman Good, Ranking Member DeSaulnier, and esteemed members of the subcommittee, thank you for having me here today. My name is Doug Omen, and I serve as the Iowa Insurance Commissioner. I have served in that capacity since 2017. We regulate both insurance and securities sales in Iowa. I appear today because of my concerns about the recent DOL fiduciary proposal. The proposal could have significant repercussions for the insurance regulatory framework and negatively impact consumers. Given the retirement savings gap, the Department of Labor should be encouraging, not limiting, access to well-regulated retirement guidance and products, such as annuities. Iowa plays a significant role in protecting consumers who purchase life insurance and annuities. We serve as the domiciliary state for approximately 40 life insurance companies, the 10 largest of which hold nearly $90 billion in assets. First, I am disappointed with the DOL's lack of substantive engagement with state insurance regulators. I expect that the DOL would want to fully understand our authority under these new best interest rules before this recent expansion into the retail annuity market. That did not happen. Further, I fundamentally disagree with the administration's characterization of state consumer protections around annuity sales as inadequate. Differences in regulatory philosophy should not be understood as a shortcoming. Over 150 years, the state-based regulatory approach has proven to be robust and responsive to the needs of our consumers. The regulatory landscape for annuities has dramatically changed since the last fiduciary proposal due to the diligent work of state regulators and state legislators. In 2020, the NAIC revised the suitability and annuity transaction model regulation, adopting a best interest standard of care. The NAIC's best interest rules require producers, when making annuity recommendations, to act in the best interest of the consumer without placing the producer's or insurer's financial interest ahead of the consumer's interest. Currently, 42 states have implemented the best interest rules. In this effort, I was significantly involved in every stage of the work leading up to the adoption of the best interest rules. We gave serious time and thought to determining the appropriate standard of care for annuity sales. While we did consider a fiduciary approach, we found the fiduciary-only standard would restrict consumers from cost-effective access to the financial security products they need. In the 3 years since our adoption in Iowa, we have found consumer choice facilitates consumer access to retirement products. Iowans can obtain professional financial advice through fee or commission arrangements based on their needs. Consumer protection is best achieved through consistent enforcement of the requirement that the recommendations must closely align with the consumer's best interest, not by limiting access to well-regulated retirement guidance. I will now cover some specific objections. Our detailed objections are outlined in my written testimony and the comment letter submitted by my department to the DOL on January the 2nd. First, I am troubled by the DOL's inaccurate claims about the NAIC's best interest rules. The DOL contends that the best interest rules do not put the consumer first. This is wrong. The best interest rules explicitly mandate producers act in the best interest of the consumer. Additionally, the DOL claims the best interest rules do not adequately restrict compensation-related conflicts of interest. However, the standard expressly prohibits sales contests, sales quotas, bonuses, and non-cash compensation based on specific sales of annuities within a limited time frame. The DOL also claims the best interest rule permit producers to recommend products that are worse for the consumer because they are better for the producer or insurer's bottom line. This is wrong. The best interest rules require the consumer's interest takes precedence. Our regulatory philosophy is to focus on the requirement that the recommendation must be in the best interest, requiring the recommendations must closely align with the consumer's situation, needs, and objectives. The consumer's best interest must be first. Lastly, the DOL claims the state's annuities regulations vary from state to state. This is wrong. 42 states have adopted the best interest rules, and we anticipate broader adoption by the end of 2024. The DOL's proposal poses a substantial threat to the ability of Iowa and other states to regulate life insurance and annuity markets effectively. Thank you for the opportunity to present these concerns, and I do look forward to answering any questions that you may have.
Thank you, Mr. Oman. I will now recognize Mr. Roberts for 5 minutes.
Good morning. I would like to thank Chairman Good, Ranking Member DeSaulnier, Chairwoman Fox, and Ranking Member Scott for inviting me to testify today. I also thank all of the members of the subcommittee for their dedication to improving the retirement security of American workers. I am a principal with the Groom Law Group in Washington, D.C. I concentrate my practice on ERISA-related matters involving retirement plans. I have counseled on issues relating to ERISA's fiduciary responsibility and prohibited transaction rules for more than 30 years. My testimony this morning reflects my own personal views and not those of any client, my firm, or my colleagues. I am not testifying on behalf of a client or any other party, and I am not being paid in connection with my testimony today. The topic of this hearing is the U.S. Department of Labor's overreaching 2023 proposal to redefine persons who function as investment advice fiduciaries for purposes of ERISA and the Internal Revenue Code. The DOL proposal exemplifies the proverbial warning that even when an action is undertaken with the very best of intentions, it may nonetheless lead to harmful results. In this case, the department's motivation in advancing the proposal undoubtedly was with the best of intentions and with the objective of improving retirement saver outcomes. But the effects of implementing this proposal would be disastrous. The proposal would do harm to the retirement investor community by depriving it of access to much needed information, products, and services. The proposal would impose numerous additional regulatory compliance burdens on investment professionals who who serve the needs of retirement investors, and in particular, on those who serve the needs of lower and moderate income investors. The effect of those added burdens would be to leave large segments of the retirement saver community either unserved altogether or underserved. I would like to briefly explain why this is the case. The DOL proposal would sweepingly confer ERISA fiduciary status on virtually all financial professionals and salespeople, including broker-dealer representatives and insurance agents. But ERISA fiduciary status is not something to be assigned lightly, nor should it be assigned in contexts where it would be inappropriate. This is because ERISA imposes a high standard of conduct, the highest known to law, on persons responsible as fiduciaries to ERISA plans. The ERISA fiduciary standard of conduct does not require merely acting in the best interest of plan participants and beneficiaries. It requires acting prudently and solely in the interest. Layered on top of that general standard of conduct are ERISA's prohibited transaction rules. Those rules disallow fiduciaries from acting in transactions where they have a financial interest and from receiving compensation from third parties in connection with the transaction unless, number one, an exemption is available, and number two, the fiduciary complies with the conditions of that exemption. Under the DOL proposal, otherwise ordinary sales commissions and other traditional forms of transaction-based compensation earned by insurance agents and broker-dealer representatives would automatically be transformed by the prohibited transaction rules. Those commissions would give rise to an illegal kickback each time an investment professional makes a sale to an ERISA plan, plan participant, or IRA owner, unless that investment professional adheres to the department's exemption conditions. But here's a key watch-out. The department's prohibited transaction exemptions afford no relief, none, from the general standards of fiduciary responsibility under ERISA. An ERISA fiduciary, even when complying with an exemption, remains obligated at all times to act not just in the best interest, but solely in the interest of plan participants and beneficiaries. In many contexts, the application of ERISA's fiduciary standard of conduct is entirely appropriate and is protective of participant interests. But when fiduciary status is inappropriately assigned, it can have the opposite effect. This is the case with the DOL's proposal. Inappropriately assigning fiduciary status to investment professionals, such as broker-dealer representatives and insurance agents who are compensated on a transaction basis for the receipt of sales commissions, will produce tragic results. It will curtail retirement savers' access to much-needed financial assistance, and the proposal is not needed. Federal securities and state insurance regulators have separately adopted best interest standards for sales conduct for their respective industries. Thank you for the opportunity to appear this morning, and I look forward to taking your questions.
Thank you, Mr. Roberts, and we'll now recognize Mr. Pfeiffer for 5 minutes.
Thank you. Oh, there we go. I'm here on behalf of the investors myself and my colleagues at PIABA have represented. PIABA, the Public Investor Advocate Bar Association, is a bar association of hundreds of attorneys around the country that have dedicated their lives to representing investors that have been the victim of financial advisor misconduct. I have represented thousands of investors in my 25-year career, and collectively, PIABA members have represented hundreds of thousands of investors. Our clients are people who, invariably, trusted their financial professional. After all, the vast majority of these investors gave their entire life savings to their advisor. None of the people that I have ever represented realized that their advisor might be held to a standard anything below that of a doctor or an attorney. It's not like people come out of the womb believing brokers have a fiduciary duty to their clients. No, it's because the financial services industry has been marketing and advertising that their advisors live up to a fiduciary duty. The industry often refers to financial advisors as, quote, trusted advisors, or compare themselves to doctors. As one company puts it, quote, as doctors take care of physical health, good financial professionals help take care of financial health. Just as you consult a doctor for a range of health questions, you can work with a financial professional on a host of different options regarding your plan for retirement. Academic studies that have looked at this issue conclude what is obvious to anyone who has ever met an investor who has been the victim of conflicted advice. That is, investors do not know the duties their financial professionals owe them. One thing is clear. Right now, the very same advisors that advertise like fiduciaries routinely dispute that they owe a fiduciary duty to their client. Firms advertise like they have duties of doctors, but litigate like they owe no more duty than that of a used car salesman. The Department of Labor rule would go a long way towards holding firms accountable in the retirement accounts for the duty they already say they have and that investors already believe they have. What does this mean on an individual level to investors? For some, the difference between receiving conflicted advice and receiving advice solely in their interest is a difference between being able to afford to visit their grandkids or not, being able to afford a retirement home near their children or living with their children, or the difference between being able to retire in their 60s or in their 70s. For others, it's the difference between being able to live out their golden years with dignity, knowing that their hard work and savings is paid off, or being shattered by the reality that by trusting their advisor who gave conflicted advice, they are left with nothing to show for 30 or 40 years of hard work and savings. Almost every week, we see a retiree come into our office who's lost a substantial amount of their life savings. These are often proud, strong workers that if they go on vacation at all, they travel in a car like I did when I was growing up. They've saved to pay off their house, put their children through college, and build a nest egg, all on middle-class salaries. Now, these proud, strong Americans, they break down in my office when I explain to them how their investment was lost to conflicted advice and that their advisor did not owe them a fiduciary duty. I've had clients live with me because they couldn't afford the gas and lodging to drive back and forth to a long trial. I've had clients that ran out of money and had to rent a room from their ex-spouse. And I have even, unfortunately, had clients attempt suicide. I know the devastation that losing your life savings can have on hardworking Americans. This rule will make this better. The members of PIABA and myself see the effect of this conflicted advice on an individual level every day. One of my clients worked at a chemical plant for a major corporation, making $80,000 a year, until he got the conflicted advice that he should cash out his retirement account and roll over his entire savings to the financial advisor. He was out of money before he was eligible for Social Security, and he had to go back to work at that same plant stocking vending machines for $10 an hour. Now, this rule doesn't just help investors. It also helps ethical advisors. I think that most advisors are good, ethical people that try to do right by their clients. I use a financial advisor. My best friend, Mark Bailey, is a financial advisor, and he's here behind me today. This rule would help ethical advisors by clarifying that when advising folks on their retirement money, investors must always come first. And it evens the playing field for advisors who are already doing the right thing and acting in their client's best interest. I appreciate the opportunity to talk to the subcommittee about this important issue, and I urge the DOL to promptly finalize this rule so that workers and retirees across the country get the fiduciary advice that they deserve and they believe they are already getting. Thank you very much. I look forward to your questions.
Thank you, Mr. Pfeiffer. And finally, we'll recognize Mr. Berkowitz for 5 minutes.
Good morning, Chairman Good, Ranking Member DeSaulnier, Chairwoman Fox, and Ranking Member Scott, and members of the subcommittee. My name is Jason Berkowitz, and I am the Chief Legal and Regulatory Affairs Officer for the Insured Retirement Institute. IRI represents the entire supply chain of the insured retirement industry, including insurers, distributors, asset managers, and solution providers. I'd like to begin by thanking Chairwoman Fox and many other subcommittee members for your longstanding commitment to enhancing retirement security for all Americans without impairing access to valuable products and services. And thank you for the opportunity to share our views about the DOL's latest fiduciary proposal. Let me start with one very clear statement. I am not here today to oppose a best interest standard. IRI wholeheartedly believes that all consumers should be able to trust that advice they receive from financial professionals is in their best interest. Our industry is full of good, hardworking financial professionals who share this perspective. I am here today to oppose the DOL's proposal, which goes far beyond a best interest standard and would harm those who most need the guidance and assistance of financial professionals. Retirement savers face many risks as they strive for financial security, including the risk of running out of money. Protected lifetime income products help savers manage this risk, and professional guidance helps them acquire and use these products appropriately. Congress recognized this when it enacted the Secure Act and the Secure 2.0 Act, bipartisan laws designed to strengthen our retirement system by expanding access to these valuable products and services. Conversely, the DOL proposal, which is functionally equivalent to the now vacated 2016 fiduciary rule, will foster widespread retirement insecurity just as that predecessor rule did. Millions of low and middle income workers, especially those most impacted by the wealth gap, will find it nearly impossible to access the products and services they need to achieve a secure and dignified retirement. By contrast, best interest rules adopted by the SEC and 42 states and counting are working to protect consumers without putting unnecessary roadblocks between consumers and the products and services they need. IRI supports those measures, which provide regulators with the tools they need to protect retirement savers and appropriately address the conduct of bad actors. With these rules in place, the DOL's proposal is a solution in search of a problem. The DOL has hypothesized that regulatory gaps exist and are being exploited to harm retirement savers, but it has produced no evidence to support that theory. If bad actors are exploiting regulatory gaps to harm retirement savers, those gaps should be addressed through targeted rulemaking. But a targeted approach is impossible without clear evidence of a problem. So instead, the DOL wants to completely upend the existing regulatory framework. They've characterized this proposal as a best interest rule, even going so far as to assert that anyone complying with the SEC's regulation best interest should have no problem operating under this proposal. This is simply not true. Under ERISA, the department can only regulate the conduct of those who trigger fiduciary status. So the proposal would shoehorn nearly all financial professionals into that status. You may be wondering, why is that a problem given our support for a best interest standard? It is a problem because ERISA fiduciaries must act, quote, solely in the interest of participants and beneficiaries for the exclusive purpose of providing benefits to participants and their beneficiaries, end quote. Merely acting in the client's best interest is not enough to satisfy this standard. As a federal appeals court recognized when it rejected the 2016 rule, fiduciary status should apply only when there is a special relationship of trust and confidence. DOL has tried to circumvent that decision by asserting that that sort of relationship exists whenever a financial professional makes a recommendation to a retirement saver. We disagree. A special relationship of trust and confidence cannot spring into existence spontaneously, but rather must be intentionally cultivated over time. Pretending otherwise will deepen the nation's retirement crisis and further exacerbate retirement insecurity among your constituents. Instead, the DOL should recognize the limits of its jurisdiction and let the SEC and the state insurance departments do their jobs as Congress intended. This proposal is not fixable, it is not needed, and it must be withdrawn. Thank you, and I look forward to answering your questions.
Thank you, Mr. Berkowitz. Under Committee Rule 9, we'll now question witnesses under the 5-minute rule. I will wait to ask my questions at the end and therefore recognize Mr. Wahlberg from Michigan for 5 minutes.
Thank you, Mr. Chairman, and thanks to the panel for being here. This is an ongoing discussion with all sorts of changes in stance, and I'm sure that since 2010, DOL's attempts to change the definition of an investment advice fiduciary have created costly and constantly shifting a landscape for all of us. Mr. Berkowitz, can you discuss the costs and confusion the industry and the retirement investors have faced due to DOL's shifting stance on the fiduciary status?
Thank you for that question. Look, we've had a situation here that's been going on now for a decade and a half, basically. And we've had fits and starts where the department has put out a proposal, withdrew the proposal, came back 5 years later with an even more stringent proposal, found themselves in court after finalizing that rule, had that rule overturned, took another stab at it in 2020 with rules that actually did go into effect and are working as designed, and now just 2 years, 3 years later, are again looking to change the rules of the road. And along the way, we've had SEC directed by Congress to study this issue of what standards should apply. Studies were done, decisions were made by the SEC about how they should regulate the conduct of financial advisors. The NAIC has responded, as Commissioner Oman referenced earlier, and adopted a very strong regulation concurrent with what the SEC did with regulation best interest. Moving the goalposts constantly does not allow for the situation to settle, for firms to say, okay, we understand our responsibilities, for advisors to understand their responsibilities, to adapt their practices appropriately, and to be able to then make changes and implement those and then follow through on them and give regulators time to examine those. At this point, the examination of whether these rules are working or not is still ongoing. We believe that it is. Everything we're hearing is that it's working, but that needs to continue. And changing the rules of the road before those analyses are complete makes really no sense and will just create more confusion along the road.
Yeah, it seems that a bobblehead mixed with whack-a-mole climate isn't helpful. Mr. Roberts, since the U.S. Court of Appeals for the Fifth Circuit vacated the 2016 fiduciary rule, a new framework governing the standard of conduct of financial professionals has been put in place. The Security and Exchange Commission has implemented the regulation's best interest standards, as has been discussed. DOL has implemented a new proposed transaction exemption, and the National Association of Insurance Commissioners' best interest rule has been adopted in 42 states, as was mentioned. How have these new rules affected the regulatory landscape, and could you comment on whether the new regulatory framework is working?
Thank you for your question. I'd be happy to. The facts recounted in your question evidence the fact that there has been tremendous forward progress in enacting appropriate standards of conduct for investment professionals, including investment professionals who are compensated on a transaction basis and who work for broker-dealers and insurance agents. Both industries are subject to a best interest standard of conduct. That's a tremendous forward momentum in the consumer protections that are available to protect retirement savers today.
Yeah, appreciate that. Commissioner Oman, did DOL work with the states to develop the proposed fiduciary rule?
They had some very limited contact with some of our full-time staff, but nothing substantive was ever discussed.
Nothing significant.
So the answer to that question is no. And we believe that really it would be important to have those discussions to make sure that the regulation as it moves forward, it would be complementary of what's happened at the SEC as well as the states.
Yeah, the coordination is so important on this, especially since we're talking about people who are vulnerable. They don't know what they're doing. They just want the outcome to be good. So do you have any other concerns with the way DOL has handled the development and rollout of the proposed fiduciary rule?
Yes, I mean, the support for their rulemaking really in a large part was to discredit the work that was done at the state level under the NAIC best interest rule. And frankly, that was based upon unsupported speculation because they never spoke to us. The rules had dramatically changed. We are in the midst of implementation reviews and enforcement. So you would think that before they started to make those sorts of speculations about the meaning of our rule, they would speak to the people who drafted it.
You would hope so. Well, I see my time has expired. I yield back.
Thank you, Mr. Wahlberg. We'll now recognize Mr. Norcross from New Jersey for 5 minutes.
Thank you, Chairman, and to the leadership for holding this important hearing. This, in many ways, is personal for me. I grew up and became an electrician and was blessed to be able to work for the IBEW for close to 45 years, the last 17 of which I worked as the assistant manager. And as part of my duties, several times a week, we would have members come in with a smile on the face into our office, and you knew that smile because they were coming in to retire, to sign the papers, to start that part of life. They worked hard, they played by the rules, and they want to be able to retire with dignity. And certainly when we see that, a conversation with myself as a representative, so important because they get so much information on how they should invest their money. And we would freely share with them the experiences of many other members. Well, the idea of having a member come in and hear a story where, like you, Mr. Pfeiffer, he was sold a bill of goods and he walked away with nothing. Now, that was over a dozen years ago, but the pain is still there. We've been at this for close to a decade. Where we were 10 years ago and where we are today is a very different world. The industry has come a long way. Are we perfect? Not. No, we're not. But the idea of understanding that, and anecdotally, there's always going to be those bad players out there no matter what we do. But the idea of not being able to retire because somebody ripped you off, it's just heartbreaking. We all can see that. But the idea that many of these things, and this is a highly complex issue, and I want to applaud Mr. Wahlberg. We worked together on many of these issues over the last few Congresses, talking about annuities and having the ability to put them in the qualified default investment alternatives. And you would read somewhere that the idea of having fixed income through an alternative, or what many people would look at as an annuity, I think the baby is going out with the bathwater. So I implore us to work together to get this thing right. I can't tell you how important it is. Certainly, many of the folks that I have worked with my whole life are very much in favor of this, but I don't want the baby thrown out with the bathwater, because historically, less opportunities for those who really need advice, because the industry pulls back for fear that they're going to be sued. So I want to start out, Mr. Berkowitz, when you look at some of the issues that are before us concerning annuities, give me your view on where you think they are in terms of what would fall into the fiduciary rule. Because one of the concerns I had is back then, if I was a business agent today, would I be considered under this rule of a fiduciary?
Thank you for that question, Congressman. And yes, I do think that there is a risk that under this rule, in that capacity, you would have been subject to fiduciary status in the course of performing those duties. Annuities are a product that can be used, if properly used, can sustain someone through their retirement years to ensure that they don't run out of money, to ensure that they don't get to that $0 staring at them in their account balance when they still have life left to live. And by providing a regulation such as this that makes it harder to make those products available, you're hurting the very people that is supposedly being helped here. And so what we think is the regulatory system needs to be designed to ensure that if you are making a recommendation, you should have to act in your client's best interest. The SEC has done that. The NAIC and the state insurance departments are doing that. It is unnecessary at this point for the Department of Labor to layer on additional obligations. Now, if you cross
I have 45 seconds, so I really appreciate it. I want to give Mr. Pfeiffer an opportunity to chime in here, because the idea of where we are 10 years ago and where we are today, please.
Sure, and I think we have made some progress. However, it's not enough. There are still big gaping holes in the regulatory system. Reg BI, for instance, does not cover advice to plans. Reg BI does not cover advice to annuities. I'm not saying you can't sell annuities to a retiree. That's not what I'm saying. I'm saying that it should be governed by a good, solid fiduciary standard like the DOL has proposed, rather than the model rule, which doesn't even count compensation as a conflict. If compensation isn't a conflict, what is? And it's directly related to what the investor's savings. The more the compensation to the advisor or the insurance agent, the bigger the surrender period, the bigger cost to the investor.
Thank you. Unfortunately, my time has expired. I yield back.
Thank you, Mr. Norcross. We'll now recognize Mr. Allen from Georgia for 5 minutes.
Thank you, Mr. Chairman, and thank you for this timely hearing based on this DOL ruling. Obviously, all of us believe saving for retirement is crucial for American families, and access to professional financial advice should not be hindered by burdensome overregulation. However, the Biden Department of Labor's recently proposed fiduciary rule is nothing more than a recycled Obama-era disaster. It does more harm than good to the very people it is claiming to protect, and that's American retirees and savers. We don't just have anecdotal evidence that this will lead to decreased access to financial advice for Americans, but actual data is shown by an almost identical rule issued by DOL in 2016 before the Fifth Circuit vacated the rule in its entirety in 2018. A Deloitte study shows that the 2016 rule limited or eliminated financial advice to 10.2 million accounts. Both sides of the aisle urged DOL not to reduce access as expressed in a 2015 letter from 96 House Democrats and a 2023 letter from Senate Democrats showing their concern. This is precisely why I plan to introduce a Congressional Review Act joint resolution of disapproval on the DOL's fiduciary rule as soon as it's finalized and transmitted to Congress. Commissioner Oman, Congress passed Secure 2.0 to encourage retirement savings. Could you outline how DOL's fiduciary proposal could have the opposite result? And that is, do you think the proposal will decrease access to retirement savings like the 2016 rule did? And please explain.
Yes, Representative, yes, I do fear this regulation will have the opposite effect of the intent of the Secure Act. The numbers show that between now and 2027, 4.1 million Americans will be turning 65 every year. That's 11,200 a day. The median household for earners here in the U.S. is 63,000. It's important to know that the median income among annuity owners is 76,000. So these are products that really are targeted to provide retirement security for individuals that are not wealthy. These are middle class and lower middle class individuals that are planning for their future. So yes, it is our view. In fact, we took those issues into consideration as we looked and studied whether a fiduciary-only approach makes any sense at all. So we do view that we are interested in working with you to try to advance that, closing that retirement gap, and we
Exactly.
believe that the DOL's rule is going in the opposite direction.
Yeah, we don't need to discourage it. Mr. Roberts, the U.S. Court of Appeals for the Fifth Circuit Court, which Mr. Wahlberg brought up, vacated the 2016 fiduciary rule. The court explained that under ERISA, fiduciary status may only be imposed when there is a special relationship of trust and confidence. How does the current fiduciary proposal address this issue, and does the fiduciary's proposal approach comply with the Fifth Circuit's decision?
How the Department of Labor's current proposal could possibly be consistent with the Fifth Circuit's ruling on the prior proposal is a real head scratcher. I do not see it. The Fifth Circuit said very clearly, that when Congress enacted ERISA, it did not intend to impose fiduciary standards on persons like stockbrokers or insurance agents who are professional salespeople. It distinguished the conduct standards applicable to salespeople from the conduct standards applicable to fiduciaries, like trustees. Trustees are what they were talking about, and folks who function like trustees who are in a relationship of trust and confidence. So I see absolutely no consistency between this current proposal and the Fifth Circuit's rule.
Mr. Berkowitz, obviously this is in contrast with SEC regulation, best interest, and NAIC interest standards. I mean, who would stand to benefit or profit from this rule? I mean, we're looking at more litigation, trial lawyers. What's the deal here?
Well, look, and thank you for that question, Congressman. I think that the intent here, we want to assume the best of intentions from the department, but in reality, it is the consumer who will suffer the most. Who will benefit? That remains to be seen, but I can assure you that it will not be the consumer.
Yeah, gotcha. Great. I yield back, Mr.
Thank you, Mr. Allen. We'll now recognize Mr. Courtney from Connecticut for 5 minutes.
Thank you, Mr. Chairman. And like some of us, we've been through this rodeo for a while. And but I thank the witnesses for your input here today. But I have to just say at the outset, I mean, I understand painfully that, there's a real honest disagreements, in terms of the, the scope of the rule, the language of the rule, which I think is fair game. I think everybody, has, a good, I think, point to make sometimes in terms of just, again, the way it was drafted, and we went through this, as I said once before. But I have to say, Commissioner, I was reading your testimony on page 5 where you said that I would be remiss if I did not also express my concerns that DOL has overstepped its statutory authority in promulgating this proposed rule. I mean, to me, that sort of gets to a much more almost ideological question about whether or not DOL really should be even involved in this. And I mean, with that logic, the 1975 5-part rule really should be like repealed and eliminated. And I just wanted you to clarify. I mean, do you really think that DOL should completely absent itself and get rid of the 1975 rule?
No, that's
well,
not.
Then why did you put that in your testimony, that that DOL has no role there? Of course, they're an agency, administrative law, from every department, from the Department of Defense to the Department of Education. They issue regs constantly, and this is well within the scope of ERISA in terms of DOL's authority. And again, I appreciate the fact that you say you don't want to repeal the 1975 law. I think that's very inconsistent, honestly, with the language of your testimony. Mr. Pfeiffer, again, just to sort of talk about a few sort of, comments that have been made here, which really have just sort of created, in my opinion, a false equivalency between the 2011 proposal and this proposal. And again, if you could just walk through again the fact that this is not like the 2011 proposal was put through a copying machine and it's back before us again.
Absolutely not. It's a totally different rule with a much, much more narrow, more of a rifle shot focus. It gets at people and makes the earlier rule made a lot of people fiduciaries, and it subjected even things like websites and robo-advisors to fiduciary standards. And so that turns out to not, the Fifth Circuit overturned that. They went back to work and they sharpened their pencils and really narrowed the rule. And so now, who is a fiduciary? It's someone who has discretionary authority over an account, meaning they can trade in your account. Someone who calls themselves a fiduciary, and someone that, as a regular part of their business, provides advice based on the particular needs or individual circumstances of a retirement investor, and gives advice that may be relied upon by the retirement investor as a basis for investment decisions that are in the retirement saver's best interest. That's a narrow standard, where we had a very broad standard before. Also, the previous rule contained a contract requirement, and that, I think, was a lot of what the Fifth Circuit had a problem with. That's not in this rule.
Well, I think that's important to note that, people should take a deep breath here and just sort of recognize, acknowledging the role of insurance commissioners. Again, our commissioner in Connecticut, Andy Mays, I respect and really admire to the highest degree. But honestly, I think he understands, I don't want to put words in his mouth, but I think it's coexistence. It's joint jurisdiction. And I think you did allude to that, at least in your testimony, that both states and the federal government have a role here. And it's a question of just getting the right balance to make sure that we're not seeing these horror stories like my friend Mr. Norcross just described. They are still happening, okay? And they should not happen. And that's really what I think, we should, hopefully be able to have consensus that that's a problem, a real problem, and that we should try and figure out a way to solve it without, again, just, going through wash, rinse, and repeat in terms of just, handcuffing the department's role, which I think is legitimate. And I think that, that's what, when ERISA was passed and in 1975 an issue, regs were issued, that was consistent with the intent of Congress. And again, we should all have plenty of time to, debate and talk, and there's comment periods and all that built into the system. But to sort of shut it down and just go right back to the status quo. And again, NAIC has put out its proposals. That's great. Doesn't have all 50 states, so it's leaving some people out. And the fact of the matter is, it really, it's not the 10 Commandments. And we really need to sort of work together to get the best product using both people of goodwill at both levels of government working together. I yield back.
Thank you, Mr. Courtney. Now recognize Mr. Burleson from Missouri for 5 minutes.
Thank you, Commissioner Omen. We should all be able to agree that the Department of Labor is changing their position on what it means to be an investment advice fiduciary 3 times in 3 years is onerous. The costs and the confusion that goes along with this are clearly not in the best interest of either the providers or the individual savers or retirees. What do you see as the biggest concerns with the way that the Department of Labor have developed this new proposal?
There were just comments from one of your fellow subcommittee members about that lack or the encouragement to have that communication. There was no communication, in my view, with regards to the development of this rule. I've been doing enforcement for a long time. I worked in the Missouri Insurance Department as well as served as an assistant attorney general prosecuting scam artists. I can also tell stories of people that were ripped off by insurance agents and securities agents. From my perspective, that what we need to make sure is when regulations are put into place, that they don't punish the well-intentioned individual, the investment advisor, the fiduciary, frankly, the insurance producer who's doing the good work. And in my experience, that's been the vast majority. The Department of Labor seems to just be overreaching with their view that there should be a fiduciary mandate. Commission structures and transaction-based are often the most cost-effective way by which middle Americans can receive good advice. With the state, we focused on making sure that the advice is solid, that it does put the interests of the consumer first. And so my criticism of the DOL has really been the lack of opportunity to sit down and have some of the reasoned discussions. As for the comment period, I got my comments in. We worked through the holidays. It was very abbreviated in my perspective in trying to meet those requirements. So to be frank, I don't think the DOL was open for discussions. But that would frankly be
It was open for what, 39 days?
Something like that. And again, this is through the holidays, so it was basically all due right after the new year.
And your responsibility, let's talk about the state's role in this. We assume that we have to have all the answers on the federal level, but the state plays a role in not only managing the activities, the licensing, everything that goes into the people that are able to do business in their state.
We began our process in revising our standard to a best interest standard before the court struck down the DOL rule. We looked at a fiduciary-only approach, but we worked together, and it's true, there are 42 states that have adopted this, but I expect by the end of this year, we will be approaching 50. I know it's moving in those states that have not yet adopted it, so I'm very confident certainly by early 2025, we will have all jurisdictions. But yes, I mean, the efforts that went into this were really designed to ensure that consumers had choice. In Iowa, we have a very large agriculture business. The distribution for annuities for self-employed individuals and those that are in farming is very different than the distribution that you might find in some of our urban areas. And it's really important for that distribution to be available for all middle Americans, again, not just for those that are able to afford the fees associated with a fiduciary status.
Yeah, I can tell you, as a former investment advisor, you feel the weight, and I'll say this to you, Mr. Pfeiffer, you feel the weight of the world on your shoulders when you sit across from a retiree and you're trying to help them navigate the path to make sure that they're able to make it all the way to end of life without running out of money, right? That burden and that weight weighs very heavy on investment advisors. And so to suggest that, and within that industry, the penalties are severe. If you do an improper job, you lose your business. You could lose your business. If you do an improper job, you could be sued by Mr. Pfeiffer and his law firm. So there is currently a lot that's already in place to to disincentivize the bad actors and and I think that there's already innately, benefit. If you do a good job, more business follows.
Again, in Iowa, I regulate both securities transactions and insurance. So I have the responsibility of imposing that sort of punishment, discipline on investment advisors, insurance producers, insurance companies, across securities broker-dealers, across those various means of which these products are distributed. And to be frank, I believe that the standards matter a great deal, but more important than that is the enforcement. And I think that's what united us at the NAIC is that we improved our rule.
I'm sorry, the
create-
gentleman's time has expired, so I need to.
Thank you.
Thank you, Mr. Burleson.
Thank you.
Now recognize Ms. Wild from Pennsylvania for 5 minutes.
Thank you very much, Mr. Chairman. Well, I'm really glad we're having this hearing. I can't think of anything more vital to a large sector of Americans, working Americans, than our retirees. In my view, retirement savings and investment should be sacred. I suspect the folks sitting behind the witnesses from AARP would agree with that retirement savings are really essential to dignity for our seniors and people who have worked a lifetime. And so I'm deeply concerned with opposition to a rule that I think really goes a long way towards improving life for our retirees. Mr. Pfeiffer, thank you so much for your excellent testimony. As I said, I think workers and retirees and even employers who offer the retirement plans deserve to receive really sound investment advice that is in their best interest, and everybody's used the magic words about best interest. And many advisors, I want to hasten to say, are honorable professionals. This is not a diss on financial advisors. I was married to one once, and he still manages my retirement money and investments. So but I will say he happens to be fee only, and I think that's an important distinction beyond the scope of this hearing. But the loophole-ridden rule dating back to the Ford administration allows unscrupulous advisors to put their interests ahead of their retirement clients and provide what's known as conflicted advice. And we've seen and we've heard that it costs our retirees billions of dollars of losses, and of course leads to a lot of heartbreak and harm to them and their families. I think it's really important to note, because we've been hearing a lot, we're going to continue to hear a lot, we read in all the testimonies about these studies or surveys that have been done, and I think it's really important for people listening to understand that these are not neutral or objective studies. They are generally done by large trade associations representing brokers and traders. These are not studies that are done by, let's say, AARP or other groups that represent retired citizens. These are literally lobbying organizations for folks who make money on this. And there's nothing wrong with making money. We know that in this country, but it is wrong to make money at the expense of somebody else, in my view. Mr. Pfeiffer, you've presented some compelling real-world examples of people who've been harmed by the status quo. I'm particularly concerned about the small dollar investors. Yes. Can you just pick up at that point and tell us what the ramifications are for people who are not born to wealth or born with a silver spoon in their mouth?
Absolutely. Small savers are the most susceptible to conflicted advice. They can least afford to have conflicted advice. And you hear about these studies, and I'm glad you brought that up, because you hear about study after study, and they're all industry-funded studies. None of them are statistically significant, random samples, or anything along those lines. What we do know is what happened after the last DOL rule. Well, the industry came in here and all over the place saying that the sky would fall and no one would be able to get advice. Well,
Meaning that the financial professionals would lose money. They wouldn't be able to make as much money.
Yeah, well,
right?
and that they wouldn't be able to serve small savers. But that turned out not to be true.
I'm going to stop you for 1 second, and I'm really sorry to do this, but I think it's important for people to know that these studies, for instance, the SIMFA one, that says it was published by Deloitte, wasn't written by Deloitte. They didn't verify, validate, or audit the information. They were simply the conduit for a broker-dealer trade association to prepare this report, right?
They were a Scribner.
They were Scriveners. And same thing with the 2021 Hispanic Leadership Fund. That one actually not only was done by a group of people in the profession, but it doesn't even apply to the DOL rule. Is that right?
That's correct. It examines the last rule, not this one.
Okay. And all of them, the NIFA, NAIFA survey, the FSI Oxford survey, all of them were done by trade associations for brokers and dealers. And that's what's being relied upon by the other witnesses in this hearing and by my colleagues across the aisle to justify trying to defeat the DOL rule. Is that right?
That seems correct.
Thank you. With that, I yield back.
Thank you, Ms. Wild. And now we will recognize Mr. Banks from Indiana for 5 minutes.
Thank you, Mr. Chairman. Mr. Berkowitz, as you know, the Obama administration tried a very similar rule back in 2016. And I want to read a few quotes from actual retirement advisors back then. One said, after 36 years in the investment business, this proposed rule will force me to fire all of my clients who do not have substantial retirement assets for investment. Another one warned, quote, this minimum fee level will be a detriment to the creation of potential plans for many small businesses and likely will result in the termination of plans by existing clients. Why in the world would the Biden administration try to bring back a regulation that would do that?
Thank you for that question. It's a great question. It's a head scratcher for me why they're trying to do this when we are not looking at the status quo here. We've heard references to the status quo. The status quo changed over the last 10 years, last 5 years with the SEC and the NAIC, and the Biden administration and the Department of Labor are completely ignoring that and diminishing the value and the viability of those regulations to justify this attempt to bring more people under the Department of Labor's jurisdiction. When we heard earlier from Representative Courtney, he wants there to be a balance between regulation by the states and regulation by the Department of Labor. Well, that's what we're talking about here. The balance is when there is a relationship of trust and confidence that rises to that level where a roost of fiduciary status should kick in, then the Department of Labor is in place to regulate that. Short of that, the SEC and the NAIC and the state regulators are there to serve in that capacity to ensure that the advice is being provided in that client's best interest. This rule is simply just not needed. It's a solution in search of a problem.
Yeah, I mean, am I wrong? I mean, it seems that this especially targets small businesses and working class families that are trying to save something to pass on to the next generation. I mean, why target them? Why would the Biden administration be hell-bent on targeting working class families?
I'd like to think that they're not targeting them, but that they are going to be the victims. Whether it's intentional or not, those are the people, those are the small businesses, those are the small savers that are going to find themselves on the outside looking in when it comes to time to plan for retirement and figure out how to best get to a secure and dignified golden years.
Do you think this rule will result in small brokerage firms having to cut their services and making it harder for them to do what they do in advising middle-income, middle-class families?
Absolutely, and really what it comes down to is what we talked about earlier, the difference between a best interest standard and a sole interest standard. The folks that you're talking about provide advice on a commission basis. They get paid only if they complete a transaction. They have a vested interest in completing the transaction. That vested interest doesn't prevent them from acting in the client's best interest, but it does mean that they can't realistically meet a sole interest standard. They cannot completely disregard their own interest because they only get paid if they complete a transaction. So in order to avoid that, they're going to have to either transition to a fiduciary model, which means they're going to have to raise their account minimums. And NAIFA just did a survey of their members, whether it's statistically viable or not. I'm not a statistician, so I can't speak to that. But I can tell you that they found from their members that right now less than 30% have account minimums, and if this rule goes into effect, that is going to go up to over 70%. And these are sizable account minimums, six-figure account minimums that the average American simply can't meet. So people are going to lose access, and it's those small balance savers that are going to be the most hard hit.
It screws the people who need the help the most. I mean, it makes no sense to me. But what type of, I mean, in that regard, I mean, if brokerage firms are cutting services or they have to increase their fees, I mean, dumb this down and play that out. What does that mean for the client?
It means the clients, just like we saw back in 2016, are going to be getting letters in the mail from their financial institutions saying, we are so sorry, but we can no longer service your account and provide financial advice or guidance or assistance. If you have transactions that you'd like us to execute, you can submit those, but we can't serve you in the way of helping you figure out what to do.
Yeah, I've said it many times before that this administration is at war with working class, middle income families in this country who right now are finding it harder than ever to save, to make ends meet, and this is another example of it, right? I mean, this is pure insanity. With that, I yield back.
Thank you, Mr. Banks. And now we will recognize Ms. Manning from North Carolina for 5 minutes.
Thank you, Mr. Chair. Thank you to our witnesses for being here today. And I want to associate myself with a comment that was just made by one of my colleagues, Representative Wild, who said retirement savings should be sacred. They are benefits that people have earned. They are critical to allow seniors to live in dignity. And for many people, the most critical issue they grapple with is ensuring that they don't outlive their retirement savings. I can tell you that's something that my 91-year-old father is currently grappling with. And for most people who are not financial experts, they must rely on retirement advisors to help them meet that critically important goal. Mr. Pfeiffer, I want to thank you for your thoughtful testimony today. Often in hearings, we hear from experts who only share statistics and figures that are hard for us to understand and certainly difficult for people who watch these hearings to understand. And they may be important to hear, but it's also important for members of Congress to fully understand who is being harmed, who is being taken advantage of, who are the victims of the kinds of rules that we're talking about. And you did us a service by sharing these compelling stories. Through the stories you've shared, there's a common theme of hardworking people who played by the rules, did everything right, only to put their trust in bad advisors who wronged them. And now their so-called golden years are not as golden as they were hoping they would be. I assume you would agree with me that that is the theme of those stories.
That's the theme of the stories, and that's what we see every day. You know, these people that are just absolutely shattered, and the loss of dignity is almost as bad as the loss of the money, frankly.
And the humiliation of having known that you relied on someone you shouldn't have relied upon. I know it's too late for the Department of Labor's retirement security rule to help the folks that you talked about. But do you think the rule would have spared them harm had it been in effect back when they were investing their retirement savings?
I absolutely think that they would have been helped by this rule.
Great. And I want to focus the rest of my time on clarifying a key point. We've heard a lot of talk about the SEC's regulation best interests and the NAIC's model rule, and it seems that some of my Republican colleagues believe that these would be fully sufficient to protect retirement savers. I disagree. There's one big gap, at least one big gap, in the SEC's Reg BI and the NAIC's model rule, and that's when it comes to advice to retirement plan sponsors. Can you talk about that for a minute?
Sure. As of now, advice that are given to retirement plan sponsors, people that are electricians that employ other electricians, people that are plumbers that employ other plumbers, people that are accountants that employ other accountants, employers, the advice to them on their plan, meaning what the workers can choose from, is not covered by a fiduciary duty. And I can't think of anything more important to be covered by a fiduciary duty because it impacts not just that person, but their workers. For instance, If someone was giving me advice and it was on securities, it might be covered by Regulation BI. But in my capacity as the owner of my law firm, it would not be covered by Regulation BI.
And do most people assume when they go to a retirement advisor that advisor has their best interests at heart?
Absolutely. I see it every single day. You know, we heard a little bit from Mr. Roberts about professional salespeople. There's not a single person that's ever come into my office that said, you know, this guy was a professional salesperson and introduced himself as such. These people trust their advisor, and they do it because they were induced to.
So, according to the research and financial services firm Morningstar, thanks to the retirement security rule, workers covered by small plans would save over $55 billion in fees in the first 10 years and over $130 billion in the subsequent 10 years. Now, there's been a lot of talk about different rules and regulations this morning and in the testimony, but I think we need to keep our eye on the ball. The existence of these rules is no substitute for the DOL's retirement security rule. In fact, gaps still exist, making the DOL's retirement security rule essential to fully protect workers and small businesses. All I can ask in my remaining 7 seconds is, isn't that right, Mr. Pfeiffer?
That is correct.
Thank you very much, and I yield back.
Thank you, Ms. Manning. We'll now recognize Dr. Fox for 5 minutes.
Thank you, Mr. Chairman, and I want to thank our witnesses for being here today. Commissioner Oman, the proposed fiduciary rule attempts to regulate sales of annuities to retirement investors, which is currently regulated by the states. The Department of Labor claims its fiduciary proposal is necessary to fill loopholes and gaps in the regulations. Is there evidence that gaps or loopholes exist and are being exploited to harm constituents?
No, Madam Chairwoman. The answer to that is no. We don't have any data or actual evidence of harm that there are gaps in the NAIC rules because they're relatively new. The states have undertaken a implementation examination of all the carriers in the country, but the answer to that question is no. It would be premature to suggest there is any actual data that our rules are inadequate.
Great. So I think you would agree with me that the proposed fiduciary rule is a solution in search of a problem.
I would agree with that assessment.
Thank you. Mr. Roberts, DOL's constantly shifting regulatory efforts on what constitutes an investment advice fiduciary have created ongoing confusion. How has this uncertainty impacted cost and compliance for retirement products and services?
The DOL's shifting positions on this have sent compliance costs skyrocketing. Financial institutions and professionals who have established business models are on a regular basis being asked to re-engineer them, to retool them, to come into conformity with exceedingly complex technical rules and regulations that seemingly appear out of nowhere. The department's estimates of the costs, in my view, are dramatically understated. There are tremendous systems, programming costs, operational costs, legal compliance costs, and all of those costs, to some extent, get passed through. So the cost-benefit ratio of the zigging and zagging that the department has taken is not productive.
Thank you very much. Mr. Berkowitz, the Federal Reserve reports that 28% of Americans do not have any retirement savings. This committee worked on a bipartisan basis to draft and pass Secure 2.0 with the goal of expanding retirement savings for the American workforce. Would DOL's latest proposed fiduciary rule undermine the bipartisan efforts of this committee by reducing access to retirement investment products for low and middle income Americans? And if you please explain your answer.
Thank you very much, Chair Fox. Yes, we definitely do believe that this will undermine the objectives and the goals of the Secure and Secure 2.0 regimes. And thank you for your leadership in helping to drive those through Congress and getting those over the finish line. The Secure Act and Secure 2.0 had numerous provisions that are designed to make it easier for retirement savers to access and use annuities and other protected lifetime income products. They were focused on expanding access, whereas this proposal is focused on restricting access. Secure Act, for example, established a new safe harbor to provide guidance for plan sponsors that are looking to put annuities in their plans, so that there's greater clarity around the obligations that they have to live up to. There's also been changes in Secure 2.0 to the rules governing the use of longevity annuities, known as qualifying longevity annuity contracts, and many other positive changes. But by changing the rules about who can provide advice to retirement savers, by restricting that advice to only those who are willing to serve as fiduciaries, you're going to lose the ability to access the advice that you need to learn how to take advantage of those improvements that were developed through Secure and Secure 2.0.
Thank you very much, Mr. Chairman. If you can use the remainder of my time, I yield back to you.
Thank you, Dr. Fox. We will now recognize Ms. Hayes from Connecticut for 5 minutes.
Thank you. And thank you to our witnesses for your testimony today, and to our friends from AARP who I see in the audience. Thank you for being here, for amplifying this issue all the time. People expect that if you work hard and save diligently, you can expect to be able to retire with dignity. The retirement process has gotten substantially more complex since the current rules were designed. Unfortunately, ERISA was enacted nearly 50 years ago and has not been updated since. The 5-part test used to determine whether someone is an investment advice fiduciary under ERISA predates the 401k by 3 years and widespread investments in IRAs by more than 2 decades. Many will need assistance with retirement, especially if they have limited savings. It takes tremendous trust to provide your personal financial information to someone else and give them control over your future by making investments on your behalf. Mr. Pfeiffer, in your testimony, you pointed to multiple studies that show the vast majority of investors, as many as 97%, already believe their financial professionals were also their fiduciaries. How would this rule protect those with smaller investment portfolios? In particular, what does it do for investors with limited access to professional financial advice?
Well, it ensures that they get good advice. Frankly, the argument that, well, the financial services industry is just going to stop giving advice to people if they can't give them conflicted advice or rip them off is offensive to good financial advisors. And it's not borne out by what happened after the last DOL rule. After the last DOL rule, like I said, the industry came in and said that everything's going to fall apart and we're not going to be able to provide advice to small investors. But what happened? 82% of broker-dealers didn't reduce their services at all. When Cetera, for instance, the broker-dealer, opened a $1,000 minimum account, they adapt.
I want to be clear. Many financial advisors are working in the best interests of their clients. In fact, 1/3 of the advisors, including more than 1,500 from my state of Connecticut, voluntarily certify as a fiduciary through the Certified Financial Planners Board. Many fiduciaries are also educators, helping their clients to learn about their savings, their investments, and why certain decisions make the most sense. So, Mr. Pfeiffer, can you also describe how the behavior of unscrupulous advisors can make it more difficult for all professionals to offer the best advice to investors?
Sure. If you are living up to a fiduciary standard, say as a CFP, a certified financial planner, and you have someone down the street that can put their interest in making a huge commission over the interest of the retiree of living a long and happy retirement, you're on an uneven playing field.
Right. Thank you. And I believe that regardless of income, Americans deserve access to retirement investments that are in their best interest. We have lots of people who are trying to piece together a retirement and really rely on the savings that they've put in to be working for them in their best interest. We're not talking about large investors who have multiple portfolios and retirement is not an issue. It's the people who work every day and put away little by little in anticipation of retirement. This rule is long overdue, an important step towards ensuring that every American can retire with dignity. Thank you all for your time and for your comments, and with that, I yield back.
Thank you, Ms. Hayes. Now we'll recognize a good friend from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Mr. Pfeiffer, we've had a general discussion. I think it's important to note what we're talking about. Somebody had $100,000 to invest and the fees were 1%. How would that differ if you got a fund that charged only 0.1% over 10 years?
Well, it's an enormous difference, and it's the difference between being able to retire a year early or not being able to retire, or 2 years early. And if you compound that over 20, 30 years of investment, it's a tremendous hundreds of thousands of dollars in difference.
And if the broker were able to get a higher fee for putting you in a 1% fund rather than a 0.1% fund, and some of these are like S&P 500, so you're getting the same returns. That would be the conflicted advice we're talking about. Is that right?
That's right, and it doesn't sound like much when you talk about 0.1% and 1%. What's 1% between friends? Well, it's the difference between being able to retire or not be able to retire. Down in Louisiana, where I'm from, they call that death by 1,000 duck bites. You know, you ultimately don't get to where you need to be.
Thank you. Mr. Oman, you indicated that 42 states have adopted the best interest standard. How does that differ from the Biden rule in terms of being able to provide conflicted advice?
The 42 states that have adopted it is not the top end of that, but I think your question relates to the issues surrounding compensation. And how it is that the states chose to treat compensation. We do believe, as a matter of principle, that compensation of any structure will present conflicts. I mean, if it's a fee-based structure, it still can present conflicts. So we viewed it as to permit the wide distribution, that there would be good and accurate disclosure with regards to compensation.
The conflict is you can be put in a 1% fund or a 0.1% fund. If you make more money gouging the client, that's a conflict of interest. You should have put them in a better deal. Now, is that legal in the 42 states?
Well, I think what you're referring to now is not necessarily an annuity transaction. It sounds to me like what you're describing as a fund is a mutual fund, which would be under the securities regiment. And I, as the state insurance regulator, also have that authority. But I don't think that applies to annuities in the same manner.
Well, Mr. Pfeiffer, are annuities covered by any of these rules?
Well, they'd be covered by the DOL rule, and it's the same deal. It's an annuity. The commission paid on an annuity is directly related to how good or bad it is for the investor. The higher the commission, the worse it is for the investor. The longer the surrender period, the higher the costs. And so it's absolutely directly related.
So may I now explain, now that I understand? So our rule does deal with that. It deals with it in terms of the cost associated with that product, because oftentimes those, what you describe as fees, are built within the structure of the contract. And so under our best interest requirement, that is a appropriate and required consideration to make sure that the consumer's interests are first and foremost.
And so the broker could not put the person in the 1% fund and get a higher commission rather than the 0.1% fund and get a lower commission?
Again, sometimes cost, your example again, I would say the answer to that would be no, they should not. But again, some of these contracts have other features, so it's hard for me to give you an absolute answer. But what is clear in our rule is that the consumer's interests, including those issues concerning costs, must be primary.
But it's just not the same standard. Of course, we talk about it being in the solely in the best interest of the retiree. Of course, it should be solely in the interest of the retiree. It is the most important decision that any retiree could possibly make. Any person, it's their most important financial decision, and it deserves the protection of the highest duty known to law under ERISA, which is what the DOL rule does.
And Mr. Pfeiffer, in the last few seconds, what happens to services to be provided, account minimums and that kind of thing?
Well, we have, like I said, real-world examples after the last DOL rule and with Reg BI, and small savers are still able to access financial services advice.
Thank you, Mr. Chairman.
Thank you, Mr. Scott. And we now recognize Mr. Desaulnier for 5 minutes.
It's an old comedy routine. It's probably appropriate for this hearing. Mr. Pfeiffer, we've talked and we've heard about this as a solution searching for a problem. Clearly, your experience doesn't speak to that. I look at this consistent with your opening comments that we're not after a class of people, we're after bad behavior amongst that. As a former small business owner, it always bothered me that I was competing against people who weren't abiding by the rules and were being more aggressive. So could you speak to that a little bit about, in your personal experience and professional experience, how there's a problem out there that we're trying to address in a manner that is very targeted and efficient in terms of a rulemaking, the Biden administration rule?
Absolutely. And there are a lot of good financial advisors out there that are trying to do the right thing, that live up to a fiduciary duty voluntarily already. But there are those that do not put the client's interest first. And this is an extremely narrowly targeted rule that gets at people that call themselves fiduciaries, that have control over accounts, or give advice specifically on the retirement. And so this is not a solution in search of a problem. This is a problem that needs a definite solution, and this DOL rule gives that solution.
Yeah, and I was never married to a financial advisor, unlike my colleague, Ms. Wild, but I've heard from friends in my district and around the Bay Area in Northern California, and I can see, that they're concerned because they're worried about overregulation, or especially if it's a small firm, an individual firm, it's complicated, and they assume the worst. So could you speak a little bit of that again, to the targeted, that people who are who are dealing with the rules in good faith, which I think we all agree we want for the industry's sake, shouldn't worry about this, and we will be watching DOL if this rule were to be affected and sustained. I assume it's going to be challenged, as the previous rule was, that this is what we want. We want to get rid of the bad behavior, which, if it's done right, and I have concerns about that, but I think this rule if it's done right, it benefits everybody who wants to abide by the rules.
I think that's right. I mean, there's a lot of onerous rules for lawyers, and nothing makes me more angry than scumbag lawyers that break those rules, frankly, because we don't, and they shouldn't, and they make all of us look bad. And every financial advisor should have a duty to put their client's interests first, especially with something as so sacred as retirement money. It's all they got, most of these people. They have this, and maybe they got a little bit of equity in their house. And that's what they have to live out the rest of their lives. That's what they have so they don't have to rely on their children after a lifetime of hard work and doing the right thing.
And the Biden administration, it strikes me, has worked very hard to anticipate this being challenged again. So in your opinion, as opposed to some of the comments I've heard that this is just the Obama administration's rule all over again, it's not.
No,
and it's very much mindful of what the Fifth Circuit said and ruled, and anticipates another challenge.
Absolutely. It's not like the Department of Labor is engaging in rulemaking for the fun of it. They're doing it because they want to address a serious problem, and they want to do it in a serious way that addressed the Fifth Circuit's problems with the rule. And they did that. They don't have a contract. They don't have a contract requirement in this. It's a much more narrow definition of who's a fiduciary. I think they have addressed the Fifth Circuit's problems.
So if this rule were not implemented, what do you see in the near future? We've heard what I would think is fairly hyperbolic language about what might happen if this rule is applied. What do you think if it doesn't? If we continue this way, is it going to get worse, or just
Well, it's absolutely going to get worse because there's really the defined benefit pension is going away. Everyone's got to rely on 401ks, and you expect people that were electricians or plumbers or even brain surgeons that I've represented to then become portfolio managers. They can't do it, and they need advice. And in order for that advice to be good advice, it needs to be non-conflicted advice.
Thank you very much. I yield back.
Thank you to our ranking member, and now we will recognize Ms. Bonamici from Oregon for 5 minutes.
Thank you, Mr. Chairman and Ranking Member. Thank you for allowing me to wave on to the subcommittee. This is not a new issue to the committee. We've talked about it a lot. I want to go to the big picture for a minute here. I am not married to a financial advisor, but in my former work as a consumer protection attorney, I dealt with people, individuals, families who had invested money based on trust and lost it. Different situations, not necessarily with a fiduciary rule, but in situations where, for example, my clients spent their whole life savings to buy a franchise because the franchisor assured them, and they relied on that their franchise would be successful. Situations where people took a second mortgage on their home because they were promised that would automatically refinance, and then they lost their homes. And Mr. Pfeiffer, your testimony is really poignant in describing these stories. This is a consumer protection issue, and I'm a bit baffled by the argument that I heard on the other side of the aisle about this is going to hurt individuals and working families. This is designed to help them. I know some of my colleagues weren't born in 1974, but I was around then, and you know, things have changed since then. It looks very different in the financial market. You know, 401ks didn't exist. People like my dad had a pension, and a pension that was going to last their lifetime. It's very different today. And to the extent that workers participate in a retirement savings plan, it's most likely a defined contribution plan, and they have to manage it, and like you said, make investment decisions. And this is not to say that people are smart or that not smart or that we're looking down on them. These are complicated products. You know, the difference between a fixed annuity and a variable, and there's just a lot of complication in these products that people who don't have the background need to rely on someone they trust. And as you said in your testimony, Mr. Pfeiffer, that most people believe that their advisor is acting as a fiduciary. And the advisors build that trust for a reason, because they're holding themselves out to that. And I know the AARP study said about 89% of people over 50, and one study said about 97%. This is the trust that's established with their life savings. So again, a lot has changed, but we still have the same rule from 1974 when the products and the world was much less complicated. So I also want to reiterate that you know, most advisors are doing the right thing, and we are not criticizing or saying, you know, all financial advisors are cheating their consumer. That's not the case. But there are some who are taking advantage. We know that. We see it. You see it in your clients, Mr. Pfeiffer. So your written testimony did an excellent job in talking about the harm that workers and their families face. And you know, the suicides, the suicidal ideation, because people feel horrible. They've lost their life savings. It's really tragic. And this is, again, a rule that's designed to protect consumers. And I know we heard in the last rounds that, you know, the sky was going to fall, and it didn't. So I also want to follow up on Mr. Courtney's point about, Mr. Almond, your quote that the DOL overstepped its statutory authority, and that rests with Congress, not the DOL. And I agree with Mr. Courtney that that's just not the case. For years, the Department of Labor has appropriately exercised clear statutory authority to regulate investment advice affecting retirement savers. And we need that. You know, it started in 1975 with the regulation. They're, you know, still on the books, continues through the issuance of the Biden administration's proposed rule. So, Mr. Pfeiffer, would you agree that the Department of Labor has clear and explicit statutory authority under ERISA to promulgate this rule?
Absolutely. That's what they're there for.
Exactly. That is what they're there for. Some have mentioned that SEC's regulation, best interest in the National Association of Insurance Commissioners model rule, would be sufficient. Mr. Pfeiffer, in my remaining time, will you please explain how neither of these is an acceptable substitute for the Department of Labor's retirement security?
Absolutely. Regulation BI does not cover advice to plan sponsors, nor does it cover non-securities, and the model rule for the state securities or state insurance commissioners does not cover compensation as a conflict, and compensation is the number one conflict that advisors have with their clients.
And if this rule were in place, advisors who were following the rule would still be able to make a living, is that correct?
Can and would.
Thank you very much. I yield back.
Thank you, Ms. Bonamici. I now recognize myself for 5 minutes. Mr. Roberts, throughout today's hearing, a number of different terms have been used to describe standards that financial advisors have to follow, including best interest, fiduciary, and sole interest. Can you explain the distinction between these standards and whether the best interest standard is sufficiently protective?
I'm so glad you asked that question, Chairman. Because we're circling around this very issue, and I think we're missing each other a little bit on this one. Mr. Pfeiffer, in his testimony, repeatedly talked about how, under the DOL standard, financial professionals would be required to act solely in the interest. And we repeatedly heard references to any compensation, any whatsoever, being, quote unquote, conflicted advice. Well, that's a fiduciary standard. With a fiduciary has a conflict whenever he or she has a financial interest. Now, the Department of Labor proposes an exemption that will relieve a prohibited transaction rule. And at the bottom of their exemption, they write, they've written it in every single one, nothing in this exemption provides any relief to the requirement in ERISA that a fiduciary must act solely in the interest. So the question is raised, folks, do professional salespeople get to have any interest? Are they permitted to be compensated? Mr. Pfeiffer says yes. But on the other hand, Mr. Pfeiffer says they must act solely in the interest and that they're conflicted whenever they're compensated. So versus a best interest standard. A best interest standard, NAIC Reg 275 says that the mere fact that a professional salesperson receives some compensation in and of itself is not a conflict with their best interest obligation. And it's so important to realize that there is a best interest obligation in that regulation. They are not absolved from acting in the best interest of their clients. They are duty-bound to do so. They're duty-bound to consider cost and whether or not the product and the cost features of the product are a match for the consumer's needs. So I think, a best interest standard is an appropriate standard for a professional salesperson. A fiduciary standard, one which would deprive the salesperson of having any financial interest in his or her activities, is inappropriate. And I did also want to address, there's a great deal of umbrage being expressed about, well, how dare anyone suggest that the Department of Labor not have the full authority to regulate the securities industries and the insurance industries. The Fifth Circuit decision made exactly that point, that Congress had reserved regulation of the securities industry to the SEC. It's reserved regulation of the insurance industry to the states, and the DOL has the power to regulate the operation of plans. There is some overlap amongst the three, but they belong in separate regulatory spheres. Thank you.
Thank you for bringing some wonderful common sense perspective to that. I appreciate you making, you could argue that every business broken down to the very base level is in conflict with every consumer's interest. If you have a restaurant, when the customer walks in, he wants to get the absolute best meal, the absolute best price with the absolute best service, and the business wants to make money off the transaction, but they also have the business has a shared interest that they want to make that customer happy, so that customer comes back again and again and tells their friends and enjoys that experience. They want it to be a healthy meal. They want it to be a satisfying meal. So there really is a devoid of understanding on the other side of that there's a long-term shared best interest for businesses that want to succeed and thrive and help those whom they serve. Do you believe that the the SEC's regulation, best interest, and the state's rules are effectively protecting retirement investors?
I do. We've been fortunate to hear from Commissioner Oman this morning, and Commissioner Oman has shared with us how his office protects consumer interests, actively weeds out and disciplines bad actors for not adhering to a best interest standard of conduct, as does the SEC and FINRA on the security side. You know, and one point Mr. Oman made also in his written testimony is that bad actors can be found in the fiduciary space. Bernie Madoff, for example, was a so-called unconflicted fiduciary.
Well said. Yeah, so I would suggest, I was going to ask you, but the cost of implementing the proposed fiduciary rule is not justified. With that, I'm out of time, and so I'm going to recognize our ranking member, Mr. DeSaulnier, for a closing statement.
Thank you. I want to thank the witnesses. I also want to thank the chairman for the reference to the restaurant business. As he knows, I used to be in the restaurant business. I used to own them, but being from the San Francisco Bay Area, I just did it for my masochistic fulfillment until I became a politician. So the analogy is a good one. I do think, he's heard this as well. Madison, one of my favorite quotes from Madison's was that if people were angels, there'd be no need for government. I think this is sort of the sentiment of what we're getting at in good faith from all the witnesses is how do we make people professionally give the standards, whether that conflict is based on enumeration or other beliefs. So we're trying to get that. I really believe the administration, particularly as a result of the Fifth Circuit's decisions, is doing that in a targeted way. Mr. Pfeiffer, I would ask you for the record to respond to some of I won't use your termination about lawyers that you used earlier, and I'm not relating this to anyone on the panel, but maybe you could submit for the record a response to what we heard from Mr. Roberts versus the technical legal aspects. You don't need to respond now. This is my closing, so you can submit it for the record, and our staff will be happy to help you with that. And let me just conclude with that I really hope we can get this right. I believe this is right. As I said earlier, I don't believe in doing regulation for regulation's sake, which I've heard from the Republican witnesses. We just want to get at the bad behavior. And I've heard that, as I've said, from friends and financial advisors in my district, both on this rule and the Obama rule. So what we're really looking for, and I disagree with Mr. Banks in this regard, from my perspective and our perspective and the Biden administration's perspective and DOL's perspective, is that a lot of workers are suffering right now. There's more pressure on middle-income people than ever, and thanks for all our supporters of this regulation in the room. I'd love to go to the ARP store after to get a jacket so I can appropriately be affiliated with you besides my age. The people who are being abused have less disposable income. A lot of people in my area in my generation, are completely dependent on their home investment for their retirement. And subsequently to helping their kids with that. So this rule getting right and protecting their retirement is really important. Neither the SEC's regulation, in our opinion, on best interest nor the fair, weaker NAIC rule, again in our model rule, comes close to fixing the problem. In my estimation, the Biden administration's proposed retirement security rule is necessary, narrowly tailored, and responsive to the Fifth District's decision, Circuit's decision. This rule is not the same as the Obama-era fiduciary rule, and the Department of Labor acted well within its statutory authority under ERISA when proposing it. The Biden administration proposed rule will significantly reduce costs to help small businesses, including restaurants, and benefit small savers who are most vulnerable to conflicted advice. There is no credible study on this rule that suggests otherwise. The proposed rule will level the playing field to ensure that workers, retirees, and plan sponsors receive advice that is in their best interest. That's what they expect and deserve. I very much support the Biden administration's retirement security rule and encourage the Department of Labor to promptly finalize it. Finally, I ask unanimous consent to enter into the record statements from our friends at ARP and the Consumer Federation of America in support of the retirement security rule. Thank you, Mr. Chairman, and I yield back the balance of my time.
Thank you, Mr. Saulnier. In my experience from 17 years in the financial services industry, on the lending side, mind you, but almost no new regulation that I saw over my 17 years, almost no mandate, no rule from the federal government, often from the state government as well, was truly in the consumer's best interest. Whether it's the privacy rule, I was working in the industry when we had the new privacy rule, where now every year, you got to send every consumer in the country these stacks of paper to throw away, telling them what their privacy rights are. The redundancy of paperwork and repetitive requirements, increased pass-through costs from an administration, by the way, that says, literally, the president said, don't pass on your increased costs to your consumers. Don't pass those on to your customer. When your costs go up, don't pass them on to the customer. Having no understanding after 50 years in government where a business, where an organization gets their revenue is the only way is to pass from their customers. The unnecessary delays and less efficiency that results from these mandates, regulations, and rules, the explosion as a result of the compliance and legal departments, or what we used to call the business prevention departments, that small firms, by the way, cannot afford, like the large firms can. I worked for a Fortune 100 company that could afford those. But I guess it did provide job growth and security for the examiners and the auditors that had to enforce these things. Federal rules and regulations are costing consumers thousands of dollars a year. It has exploded, particularly in the last 3 years. And who does that hurt most? These are hidden taxes, hidden fees that are regressive in nature. They don't hurt the big investor, but they do hurt the small savers, the small investors, the seniors, the regular income folks, and so forth. Bureaucrats indeed do not know best. Ronald Reagan famously said the 9 scariest words in the English language was, hey, I'm here from the federal government, I'm here to help you. That is so rarely the case. Business and industry professionals have again, long-term shared interests, perspectives, truly wanting the best for those who they assist, those whom they serve. They recognize that everybody wins when that is the case. And they want to stay in business for a long time and have satisfied repeat clients and customers. We shouldn't punish everyone. Quality firms and professionals shouldn't be punished, and the costs the increased costs and fees and the impaired service for investors, that shouldn't happen. Everyone shouldn't be punished because of the very few bad actors that helps lawyers enrich themselves via class action lawsuits, by the way. The Biden administration's fiduciary rule purports to address unfair sales practices by retirement advisors. However, more overregulation in the industry is not the answer. Implementing the proposed fiduciary rule will disrupt an industry that is already making progress in protecting consumers. In fact, over the last few years, the SEC in 42 states have implemented new standards to protect consumer interests. So the rule discussed today is a classic case of heavy-handed regulatory overreach by the Biden administration. Americans of all income levels should be free to choose sound financial advice on how to best save for their retirement. And it really is offensive, the contempt for the consumer that, if you're low income or if you're regular income or you're blue collar, then you just don't know how to make choices for yourself. That's really an offensive thing for some to suggest. We know this rule will negatively impact millions of Americans' ability to receive the investment advice that they need. So I urge the Department of Labor to take note of our hearing and withdraw the rule. And without objection, there being no further business, the committee stands adjourned.